Dzień dobry, witam po przerwie lunchowej.
Good afternoon, welcome after lunch break. Welcome to the second part of the Day 3 of Freedom Games. When you have good company, the time is flying. And when you have valuable, intelligent conversations, the time is flying even faster. The hope is that next year we will meet again, and by the time we will be able to think and maybe start some actions concerning the topics we have addressed. Ladies and gentlemen, this final afternoon is starting with a very important meeting on the future of judiciary system after the disaster of the Law and Justice Party. Adam Bodnar, lawyer from Ombudsman, who is the visiting professor in the Cologne University. He is sitting on many advisory boards that deal with law. Adam Bodnar, welcome to you, sir. Sylwia Gregorczyk, Abram, an attorney, social activist. The Three Courts Initiative is another panelist. I would also like to welcome Professor Krystian Markiewicz, who is a lawyer and a judge. Doctor and professor of the Silesian University. Since 2016, he was the chair of the Association of the Polish Judges Justitia. So the dialogue of our wonderful, outstanding panelists will be Zuzanna Nowicka, who is the lawyer of the Helsinki Foundation for Human Rights. Thank you very much, Olga. Good afternoon. I'm very honored that I will moderate this meeting. The main axis of the discussion is the civic rights, the rights that are governed by the jurisdiction of the Polish courts. So we have to have the three courts to have good reform of the judiciary system. The main difficulty is that maybe because sometimes the processes are very harmful, because if we think of the rights of the creditors who took their credits in francs. So Sylwia, how should we ensure the balance in the right to court with the justice of judicial rulings? Thank you for the invitation. Our main challenge is how to communicate the state that everything that concerns independence of courts, and also in the context of us trying to fix this, strong word, disaster. Well, actually I agree, it's a disaster. But the main challenge is how to explain that it will serve the good of the citizens, that it's not that all of a sudden Krystian Markiewicz and other judges will come and they will take revenge and they will introduce their own order. As a commentary concerning these creditors who took credits in francs, it's a big drama of our citizens. So when we are thinking of the reform of the three courts, we as lawyers have very long discussions. We are looking at hundreds of drafts, but at the very end there is the citizens who took a credit in francs. So it's just like a normal problem, ordinary problem. I would like to share a story I was thinking of when I was driving to the game. So I was thinking about the tragedy of some people and about the problems of attorneys. How should we behave? As you're probably guessing, most of the cases we deal with as the three courts, we mainly deal with such cases for judges, so we have to submit some proceedings, we should renew the submissions, and of course we have to be impartial. And if Judge Żurek is my client, I know why I'm going to the court, but we had a very difficult situation recently. It was very difficult. It was about a Ukrainian girl. It was before the aggression. So she was a victim. The persecutor was accused for rapes. She was made to work as a prostitute. So we were like implementing this slogan, "You will never walk alone." So she was accompanied in the court by 3 lawyers. So the hearing was very difficult, but the persecutor was jailed. So there is a client who suffered a real trauma. We, as her lawyers, informed her what had happened. It's very difficult to explain to her why this, whether the judge is the judge or not. She is most interested to have this case done with. If the client is not in jail, he will be submitting different requests. But my client, she went through trauma, she's got a baby, and she wants to have her case closed. What to do in such a situation? It's a real human tragedy. We talked to her and she made the decision, so it was easier. I didn't have to submit the request to exclude the neo judge. Whether I like it or not, I can become familiar with all the verdicts, I can take part in all the proceedings, but my client's will is of key importance. So I am in this situation. So I'm dealing with a real tragedy. So we were in front of this judge, female judge. She made her verdict on behalf of the Republic of Poland. My client accepted the verdict. So it was the real tragedy, and it was hard to explain to our client and to average citizens. But back to your question. Each construct that assumed the tripartite division, well, citizens have to have a guarantee that the justice shall be made. So if this division, this tripartite division is meant, everything is observed. Thank you. Professor, do you think that this problem can be resolved by a law? Resolved for good? Ladies and gentlemen, first of all, I would like to thank the organizers of the Freedom Games for inviting me, for being here again. Sometimes in our public debate we hear that there will be one act, one law, and it will fix everything. Grzegorz Schetyna in the past proposed something like that. He was saying that one law will be passed and rule of law will be provided. Sometimes, people think that it's a question of just one solution, but it's not so simple. Actually, many amendments had to be introduced. The courts, council, administrative courts, and all the supporting institutions such as special services. So all these entities should be reformed. For example, we should have special surveillance over special services. So we have to remember that there is the so-called constitutional trap to all of us. So even if we introduce some amendments that would approximate the courts to the compliance of their functionings with the functional standards, so the right of each citizen to the independent court, the trap is that the President and the Constitutional Tribunal can question it. And if the President implements this preventive mode, then we will not be able to do anything for months. I hope it will not happen. But it shows that maybe we will need a strategy focused on many months of very intensive work. So if we cannot manage with one good solution, then we will have to search for another solution, and we will have to pressurize entities not to make sure that the rule of law is returned. So the EU pressures are very important, as well as the pressures of such bodies as European High Court for Human Rights. We are meeting here today in the Freedom Games between 14 and 16 October, and on the 12th of October, the European High Court of Human Rights talked about the case Lech Wałęsa against Poland. It's about the contents of the dispute with. So if we read the rulings, we can see how the Polish courts work. We can actually see all the infringements, these new judges, neo-judges, abusing procedures in the European High Court of Human Rights, the court in Strasbourg. We are that many changes have happened both at the symbolical, political and emotional level, as well as the level of the number of people who are involved in the process of changes. The neo-judges themselves, it's not a small group. It depends how you count. If we include the graduates of law schools or young prosecutors who had no choice, they graduated from the school for prosecutors and they had to become prosecutors or judges. So we are looking at the thousands of verdicts. So to fix all this, we have to be prepared for long-term intensive process. At the same time, it doesn't mean that we have to start thinking about it right now. After the election, this work has to be prepared. We have to have many options in terms of functioning of these institutions. Even if this constitutional trap is set, then we have to adopt the laws that will repair specific judiciary bodies. Let's get back to the thesis by Mrs. Gregorczyk, Abram. As you have said, we have to tell the citizens, and at the same time we have to convince them that we also want to improve efficiency of the functioning of the judiciary system. In Gazeta Wyborcza weekend edition, there is my article, and I'm writing that in Poland we've got this gap in access to courts. So even if citizens would like to can go to the courts, they don't see that the courts are really for them. So people do not believe that they can deal with small things, and people need to plan. Well, if I go to the court, maybe the process will take 2 or 3 years, so it's not worth it. So we have to make sure that the citizens can see that there is no dispute, that it's not about the judges fighting, being in conflict. Now the level of comprehension is already quite weak, and now we have to be prepared that it will take several years. So it's important to prepare to draft reforms on the general functioning of the judiciary system in Poland. I would like to provide you with one figure. It's important to me because I was very involved in this. The consequences of the Repression Act of the December I can't. Sorry, I didn't hear the years. So it's of 2006. So after 6 years, after adopting this law, and then the decisions were issued by the pension offices, 25% are at the age of the first instance court ruling, and a very few of them have the legally binding decisions. It's due to the fact that Minister Ziobro is not very keen to provide extra human resources to process these cases. It shows how difficult these problems are. So not only institutional problems, but also the problems of efficiency of courts functioning. Krystian, I have this feeling that many citizens are afraid that the lawyers want to move everybody away. So how to balance what Professor said, to make sure that the system is functioning on daily basis. Thank you for the first invitation. Adam was thanking for the next one. I'm very happy. All these three questions are interrelated. There is this long-going discussion for several dozens of days. Where is the stability of the verdict, and where there is the space to address the problems that have been mentioned, for example, the problem of appointment of judges. Stability of the verdicts. We as judges, we are responsible for this. This is the issue of stability of the state. When I go to a court, I expect that my case will be settled. I will receive my verdict. That is why we were saying several years ago how dangerous it is to use this special extraordinary complaint. So we had to wait for President Wałęsa to attract the attention, to highlight such problems. And if we pretend, as we used to pretend for 5 years, that the Chamber of Audit is not a problem, the disciplinary chamber is a problem. The Chamber of Audit is not a problem, although it really threatens the functioning of state more than this disciplinary chamber. So this problem is identified, this extraordinary complaint, when the politicians have to approach the political chamber and they can question any decision, they can question proper nature of the election result. Also, such bodies as the Council for Public TV and Radio, it can all violate the stability of verdicts. So Sylwia was saying about her client who was facing a problem, and she decides that she doesn't want to exercise her right. Then we say, okay, we respect her decision. We treat the fault of appointing some judges as the right to question the verdict, not as a duty, obligation, something like this law when the pensions of the former services have been questioned. So we need the law for those who want to exercise it, not for the people who found some situations that allow for some abuses. The problem on questioning verdicts, because, for example, the judges have not been appointed appropriately. This problem has been known for the past 200 years when we think of the 200-year-old law. So if a lawyer wanted to question the verdict, he could have done it 5 years ago, 1 year ago, or even tomorrow. But he or she has to be brave enough. It's not that he is in the court and says, yeah, it's great. He or she has to work. If somebody doesn't want to exercise this right, I think such an option is lost. So we have to be sure, we have to make sure that the verdicts are stable, and we have to take care of this stability. But in a moment, hopefully as soon as possible, we will have the rule that we will be taking care for the stability of appointment of judges. So we do not want to have the situation that in 5 or 10 years time in the processes participated by such judges, all of a sudden people start questioning such verdicts, because people have this right all the time. So we either do it right now, and we will ensure the functioning of the serious state, not the state who has been using the Strasbourg court and Luxembourg court verdicts to establish the standard. We need to introduce the standard. We need to learn how to execute the verdicts, the rulings. This is when it will be good situation. It's important to everyone. So it's not only what we can get from the rulings, verdicts at the initiative of Polish judges, Polish lawyers, at the initiative of the European Commission, but there is the question whether we will be determined enough to implement this and say we are a mature EU member state. And we don't want the situation that we will be like the four-league player.
Thank you. Professor, you reverberated society's trust to courts. I'm afraid it affects general system of justice. We talk about reforms. It won't mean we'll win the trust immediately. How can we do it? I fully agree that this trust cannot be regained within a day, but we can change the vector of thinking. Through changing the vector of thinking, I mean that every politician from the opposition every day must emphasize why it's important to observe the law, legalism, and tripartition of power. It must not be the case, as used to be during the opposition's party rule, that on one day we observe it and the other day we make shortcuts because we want to force an act within a week. It used to happen, rarely, but it did. In my opinion, this is one of the most important lessons we learned throughout the last 7 years. The ruling politicians, even if it's difficult for them, even if it extends the efficacy of making political decisions, they have to shape the sense in the society that law is above all, and that they are servants of citizens. If we follow such an approach, soon we will see a different attitude of citizens to the system of justice and to politicians. But it will also mean responsibility on the judges' side. What my colleague from Ombudsman's office proposed in 2017, that judges have a debt to pay towards citizens, will be even more valid. I am aware that for some judges it will mean not necessarily being convinced. Some will claim that they were appointed by the National Council of National Courts Council, but we are doing our duties in the right way. But they have to be well conceived and they need to be clear, because our role is not only to build and to regain the trust or regain the energy we observed in the 1990s and later, but this is also the task to show, just as Christian said, that we are a serious country, a serious player, not only in Poland but internationally when it comes to shaping the future of the European Union, that we are an example to follow for Ukraine and for other candidates. However, this applies to legislative changes and engagement of all politicians, and that's something I'm afraid of. I'm afraid that democratic opposition will not stand united. On the one hand, there will be parties which will say, right, we are on this side and we implement it, but there will be another person saying, we've got excellent solutions just to enjoy a moment of fame on the political stage. So yet again, if they try to compete and rediscover the wheel, it will immediately go into vain. Another aspect is related to settlements. They have to take place, but they need to comply the rules of law and the guarantees of procedure and the right to defense. It needs to be repeated, though it's obvious. Again, if we take shortcuts, we'll give the fuel to those who will challenge this. That's another aspect to take into account, namely how to prepare the mechanism of settlements which are of conciliation nature, or which are conciliatory or amicable. Then you will say, all right, you admitted you had done wrong, that you had not proceeded according to the code of ethics, and such a mechanism needs to exist. We'll come back to settlement, but I would like to come back to the opposition's proposal related to the system of justice. Where do citizens belong in the process of change? We often hear that lawyers should be removed from the room where all these discussions take place because they are the ones responsible for the disaster. How to take into account the citizens' voice? I will answer the question, but I want to say I do agree with Adam that this is the most significant trap, not to be captured into fatigue, that we should take everybody to action, to say how to build a state which operates according to the highest democratic standards. That's the major challenge for us. Citizens' opinions and voice. It is not that we only talk about it during conferences, how we can reverse certain things. These works are ongoing with huge engagement of Justitia organization. Apart from doing their everyday duties, and apart from being subject to endless disciplinary procedures, lawyers are engaged in actions carried out with citizens and NGOs to reverse, to order and to remedy the problems. One of them is the project of memorandum for the rule of law. It was initiated by Justitia, taken over by NGOs such as Wolne Sądy, Free Courts. And they invited all politicians of the opposition to cooperation. Is it easy? Krystian is smiling. Paulina Kieszkowska-Knapik is the patient person who runs the conversations with the opposition politicians, but it's indispensable. We are at a point where we have to speak openly. As Adam said, it might happen that an opposition party member will come with a great idea just to have a moment of fame. We struggle with lots of such ideas, but we are persistent in operating on shared values, and we try to convince them. You have to remember that we do this job, we as free courts, as citizens, as the societies and NGOs. We work under the project submitted to the parliament, but it has not been popular. It assumes a number of solutions related to neo judges. It responds to the question how to activate the process to verify the new neo judges, and the other one is related to constitutional tribunal, and it was established by the Batoré Foundation. That was the project subject to the broadest consultations. The Batoré Foundation does their best to show this project to everybody. Their meetings with politicians are not easy, but they propose specific solutions related to the Constitutional Tribunal and its functioning in the future. Legitimacy for organizations, for NGOs, disciplinary jurisdiction, and also activating judges, justice emeritus, to come back to work if necessary. If you feel it does not suffice, and you might have such a feeling, I can only imagine what an average citizen feels hearing about it all. I also feel you can become indifferent. But if you feel that citizens' voices are not well exposed, please write to us, write to Wolne Sądy. We try to answer every message. The same is true for every organization dealing with the rule of law. We want to enter the dialogue because we are concerned about establishing the dialogue and bridging the gap to build the nice democratic state together. We mentioned draft acts and how to implement a reform of the system of justice, but how to ensure society's participation. Krystian, over to you. There are several related issues. I don't know, Sylwia, if you feel the same, but the major problem is not related to the flow of information between us and citizens, but between the citizens, NGOs, and the world of politics. This is the lesson related to the project for the rule of law. It has been a traumatic experience for me. What is it like? We live in a state with a population of about 40 million people, with universities, mature political parties. And after 7 years, we have 2 draft acts. One was conceived by Justitia, consulted by several lawyers from the Batoré Foundation. Some could say, well, that's still positive, but even if there are only the 2, There are people mentioned by Adam and Sylwia who have to spoil it. And that's something I cannot understand. I like Warsaw, but there are some moments when I'm happy that I live in Katowice, not in Warsaw. The future will depend on the best collaboration between citizens and system of justice. That's our opportunity. In my opinion, there is no tripartite power, but bipartite. Are we aware where the draft act or the project comes from? Nobody differentiates it. The MP's initiative is submitted by people who know nothing about it. We've got bipartite power, political and court. If it wants to operate as a separate power, it needs to have a legitimacy. Regulations are dead themselves if they are isolated. Has anybody changed the constitution for 7 years? No, they are simply violated rules. We need to be aware that in 2022 we're talking freely about independent courts, about the future of the system of justice. 2 weeks ago, I came back from Israel, where judges from all over the world gathered, and I learned that the situation was completely different there. Murat Arslan, my counterpart in Turkey, has been in prison for 6 years. One day after unfavorable sentence, a bomb explodes in front of the judge's house. We must not forget what we succeeded in throughout the years. This is our shared success. We did it all together. If we want to have real control over what politicians do, because this is what they want. They want to feel they will never be punished. But the remedy is to stand together. There is the Social Council at the National Justice Board, common discussions in Łódź, in Katowice, about the system of justice locally, so that in their towns, in their villages, they know the judges, and the judges know their citizens. It's like mutual opening. We showed over the period of 7 years that we can be the last barricade, but this is the one you cannot cross, and that's what I'm certain of.
Bardzo dziękuję. Zanim wypełniając
Thank you very much. When we talk about other things, I would still like to talk about accounting. I started delivering classes to the students of first year of the law studies, so I was asking them when we were talking about the independence of judges. So I asked them whether they imagine a situation where the judge is the husband of the person who's going to be sentenced, and they were thinking that yes, the judge can be married to a woman who has made a mistake. So, how to distinguish the people who are true judges from those who are not? If we believe in someone's intellectual independence, it doesn't mean that we should allow this person to issue ruling, because it depends how such people are perceived by external observers. You have used a case which should provide the foundation to exclude such a judge from this kind of ruling. So appearance of justice is not met. This condition is not met. So, in the context of the new judges, we will have a big problem, because even if among these people we will have a lot of judges, serious people, people who are well known from their research work, but in 2018 decided to hop on this train to hurry up with their career, to progress faster. So they ignored everything that was happening and all the threats to the independence of justice resulting from the constitutions or international agreements, including Poland's memberships in the EU. All these people should be verified using the criterion mentioned by Krystian. So what to do to secure stability of the judiciary system and the safety of citizens? It will be difficult, but it can be done. There are mechanisms that will help us to implement such process. I have 1 minute to go, so let's get back to the theme already mentioned. I don't think it's enough just to say we want to speak to citizens. Citizens have a range of organizations, institutions that help them in providing their voice, their opinion on prosecutors. There's a government of notaries, local governments in entities. At the level of the local entities, you can also hold debates to approximate the knowledge on courts and their functioning. And I would like to appeal to you. A day before yesterday, something important happened. A court disagreed to arrest for Maciej Witocki and 3 other men. So they were stopped daytime. The head of the most important organization of employers on the day when EFNI Congress started. It's scandalous. So I would like to appeal to the Polish business. Wake up! This isn't funny. This is the future of Poland. So now it's too late. We mustn't consider whether we can try to have a position worked out with the central government. All the entities, lawyers, justicia, entrepreneurs need to demand to have the state that will work according to the rules of law. Sylwia, Professor Górski calls the National Justice Board illegitimate children. Do you think they all should be prevented from giving verdicts? How to distinguish? It's not so complicated as it may seem when you listen to politicians or media. I will start by saying, just like Adam said, it's not just the chamber of audit, of control, but definitely there are people who are valuable, and to some of them it was like a tragedy. So giving verdicts in district courts for many years, maybe it was quite frustrating, so they could progress faster. So they hopped on this train. So it doesn't matter how smart they are, how many universities they have graduated from. We have to deal with this. We can't take shortcuts. And there is no mechanism. Are we going to deliver an exam on morality, on the rule of the law? There are Strasbourg Luxembourg and Polish courts determined that they are not constitutional judges. The National Justice Board is not credible. So we have to have the judges chosen in the right way. So we were talking about some projects. There are some procedures that can be implemented and they will not destabilize the judiciary system or the work of the courts. So we do not want to just stop the proceedings only because we can see new judge coming into the court. Of course, such procedure is available, but there are different processes. The judges will have to be verified whether they have been constitutionally chosen, and we'll have to make sure that these people will not want to take revenge. So this project, the draft of the agreement for the rule of law actually includes such tools. Krystian, do you think is this the right moment for the judiciary system to reformulate its structure based on the mistakes made by the Law and Justice Party? Yes, Justicia is an association which is 31 years old, and it's not that we started our work 7 years ago, although some people may think that's the case. You mentioned children.
Żeby każdy miał prawo do sędziego nieskazitelnego.
So it's not that somebody who is working as a judge for a long time, he is a good judge. So everybody should have access to the impartial judges. I do not understand what is going on in the High Court.
O tę niezależność jest to, że nie ma mieszanych składów.
We hear that there are no mixed compositions of the courts. So what does it mean? So if I'm lucky enough, I go to the good judges, the fair judges. But if I'm unlucky, I will have to deal with the three neo-judges. This is not the state should work. So if you're lucky and if you go to buy a car, if you're lucky, the brakes of the new car will be working. If you're unlucky, the brakes will not be working. And as soon as you leave the shop with the car, you will get killed because the brakes will not work. I agree with Adam. The problem is that we have to set priorities. What should be done first? In my opinion, we have wasted a lot of time during these 7 days. There is a special committee founded during the first Congress of Polish Lawyers. Of course, I would love this committee to do more, but show me other committees that have worked more than this committee. At the very end, ultimately, when the time comes, we will have to have some instruments ready. So we will see who will have the drafts of the law about the judges. Now they are talking about the judges of peace. It's the tradition dating back to the 19th century, and in most countries you can use specific programs and they are free of charge. So we can use just clerks. We need to have a vision. What has been happening for the past years shows one thing. The concept of the supervision of the Minister of Justice, who also is the Prosecutor General. This has not worked. If it's so great, why is it so bad? Why Poland is dropping in all the rankings when we're talking about the dynamics of the cases, when there is no prosecutors' enforcement to defend everyone according to the civil code or criminal code. Why? Because the minister is dealing with politics. He wants to harm judges, prosecutors, lawyers. So we also need discussion on the new way of functioning of Polish courts. In the 21st century, in the 2020s, now this formula is outdated. It doesn't work. It's like a ship that will sink anyway. So we have to propose something new and modern, which will make us the leader of Europe, or our courts will be just like a scrap.
Dziękuję. Do końca zostało nam 9 minut.
We have 9 minutes left, so I would like to ask the audience to take part in our discussion. So the lady from the front row. Thank you for this important discussion. I wanted to ask about a different topic, the issue of the Constitutional Tribunal. When we look at its competition, implementation of any law can be blocked. So what to do with this tribunal? On the one hand, we've got the theory of Professor Matczak. We could remove only the doubler judges. Then Professor Sadurski says that the tribunal has to be got rid of. We have to get rid of it. I can answer this question. When our panel ends, Professor Sadurski will actually take part in it. It will be an online connection. He will be here at 4:45. I know this dispute and the concept of Professor Sadurski. It's very attractive, but I don't know how he's going to execute this. How does he want to have the situation where the offices will be taken away from the judges who have been appointed in accordance with the constitution? I prefer Batory's foundation. So Professor Matczak is for it. So he wants to take the office away from the 3 judges. So some legislative initiatives have to be implemented. Maybe these judges should start their retirement earlier, and in this way we will fix the tribunal, but it can take several years. It won't happen all at once. So we are in this constitutional trap and we will stay in it for quite a while. It may also happen that the tribunal will not be so keen on making fast verdicts. And just to defend Professor Sadurski's concept, he often says that is the other part in my concept, dispersed control of constitutionality. So each court will take a bigger burden by making verdicts on the basis of the constitutions. We can see the courts more and more often use the constitution as the basis. So in these new times, hopefully there will be more such instances. There's someone from the 3rd row. Karol Konrad, you didn't say anything about the prosecutor's office. The future of the judiciary system is the prosecutor's office, especially when we will have to summarize all the things that have been happening within the past years. We will also have to decide what to do with the people who are offenders representing the Catholic Church. So do you have any ideas? How should they be selected? Of course, the separation of the prosecutors have to be done, so the minister will not be able to be the prosecutor general. So any ideas on this? We didn't talk about it because of our topic. Also, I don't feel competent enough. We have many friends from Lex Super Omnia, and just like Batory Foundation was working on the draft on the Constitutional Tribunal, we were working on the draft of the judiciary system. Prosecutors are developing their own drafts. Of course, this is obvious. Of course, the Minister of Justice cannot be Prosecutor General, so we need some systemic actions. It's not the draft at the stage of the assumptions. Now some details are elaborated, so hopefully quite soon there will be a publication by Lex Super Omnia. Yes, they want to speak to the politicians to consult this draft. This draft has been drafted, they are still working on it. When we talking about what you have, you were very right. The situation nowadays is as follows. Nobody counts for the prosecutors, so no proceedings are initiated by judges where we are dealing that actually the rights of the lawyers have been violated many times. We do not see sense in taking actions. That is why this Lex Super Omnia has to finalize this document to make sure that the prosecutor's office is not controlled politically. So some international PR and promoting specific people, we all know about this. So we have to make this bold line. I know you all expect this. Some harms, some crimes, let's be open about it, they will be governed and they will be processed, and we collect and archive this information to make sure that when the time comes, they are revealed and these people will be held accountable for these deeds. So undoubtedly this will have to be done. One more question. The lady on my right. I have a question. Do you think that the repair of the court system will result in the higher awareness on the importance of the law? It is all interlinked. Of course, education is necessary, starting from the nurseries. It should be a bottom-up initiative, and hopefully people will start understanding the process, because the projects introducing such classes at schools. Actually, we were proposing it 7-8 years ago, and there was no interest in these topics. But I do agree that we have to educate at schools, nurseries, during freedom games. It will improve the situation. One more thing. What we are doing right now in the context of the civil education, I mean the free courts, congresses through the constitution, meetings, discussions. So we are also trying to develop new educational methods. We are experimenting with different concepts to check whether they work or not. And these are our accomplishments and contributions to the democracy development, not only in Poland but worldwide. We are talking all the time about the increase of populism in Poland and in the world. People are very much interested in this topic. So once we regain democracy in Poland, and when we enter the path of fixing judiciary system, then we will be sharing ideas and good practices. Krystian said that in 2022 we can talk about the judiciary system, we can organize meetings, trainings, we can reach to school children, and actually there are threats waiting. So education is very important, and this will be our contribution to democracy. Your question. Our assumptions are very optimistic. I want to believe that this awareness is rising and that there will be the respect for the law, it will win. But also there is a risk that the society will be so discouraged that they will ignore these values. So I hope that our postulates will be implemented. 10 seconds for me, can I? No, we have to go ahead with the rule of law and democracy. So even if you have some more questions, you will be able to ask us after the panel. We are at your disposal. So this is what I would like to encourage the audience to. Thank you very much for this discussion. And let's have a discussion in the margins.
It's not always easy to recognize. It may look like this, or like this. It may be a burden, but it is a responsibility that we embrace nonetheless. But if it means this for one person and this for someone else, maybe it ultimately means being there for one another. It isn't handed to us, but we know where to find it and how it feels, how it tastes, and what it sounds like when we finally have it. It means different things to different people, but for many, it means everything. And if we all fight for it, it will eventually bring us together.
Network is Atlas as the name suggests, a network, and it's global. We work all around the world. We're based in the U.S. We have about 159 partners in the United States right now, and the bulk of our partners are outside, nearly 500 in total.
Atlas Network, it connects people from all over the world defending the idea of human dignity, defending human rights and personal liberties.
Atlas Network is focusing on, I think, the most important and moral cause in the entire world.
We partner with local innovators, local leaders who understand conditions on the ground in communities facing real challenges. We look at the people from the worldwide freedom movement that are passionate, are ready to make a difference, understand local conditions, and we invest in them.
At Atlas Network, we unleash individual ingenuity to enrich humanity.
The United States does not have a lock on the idea of freedom and liberty. Those ideas are beyond borders.
One of the main goals of Atlas Network is to eradicate poverty around the world, and we do that by investing millions of dollars in our partners' work every year.
Historically, wealthy nations around the world have tried to help low-income countries develop. The way we've been doing it traditionally has not really been working. So there's a movement to do development differently, and that means we need to step back as outsiders and rethink the role that we're playing in helping people in low-income countries achieve their dreams.
We want to make the world a better place. We want to make the world a freer world.
All of us want to leave a legacy and be part of something big to make a better world. This is exactly the work of Atlas Network.
With our growing number of hundreds of successful partners, we're stronger than ever.
Changing the world.
Changing the world.
Changing the world
starts together with us.